This is another case that I had on file. Again, involved emails where they were considering important city business in Ozark, Arkansas. After the Wade decision, their smart lawyers down in Ozark filed a motion for summary judgment saying there's no longer any issue, Judge. We can have these electronic communications. These communications do not meet the criteria set forth in Wade, and the complaint must therefore fail. All right? So, it's kind of hard to argue when the court says you got to have this, 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 and this to have a meeting. So, in essence, the city of Ozark was allowed to have their meeting by email exchange. We didn't see it. We don't get to see how the sausage is made. You know, they go to the meeting and the sausage is already made and they cast their vote. And there's Bill Ray Lewis always says there's two parts to FOIA. There's the open records and there's the open meeting. You know, we used to say that we had the strongest FOIA in the country. We're still holding pretty strong on open records, but open meetings have been decimated. And I'm telling you, there are meeting violations. We talk about a pandemic. There's a pandemic on meeting violations. Involved in a case over in Huntsville. Right now, this morning, we heard about the great law that was passed by Representative Flowers in they've got to go back to the legislative session. They got important business. By Representative Flowers that said that you have to record meetings. A great law, and you have to keep that law for a year. Well, Huntsville, they claim they recorded the meeting, but they recorded over it. And secondly, in terms of open meetings, they didn't give notice to the local media as they were required to do. And again, on very, very important issues. We've already talked about the mask mandate that they violated by these text messages, but the other involved assaults on our sexual assaults on children. And if we're not able to see these discussions, that's very concerning. Robin Reed, this kind of show, this was post-Wade, the post-Wade case. This shows how now the orders are watered down. Defendants admit that these text messages and SMS exchanges prior to the regularly scheduled meeting could be construed as a violation of FOIA and would therefore constitute an illegal meeting under FOIA, as the messages were not exchanged in public and notice meeting. So, you know, they don't say, like the prior order we saw, that this is a violation of FOIA and take responsibility. They say it could be, because Wade allowed them off the hook. This is a recent